This is Laura Thatcher of Thatcher Law. I help the 99% answer the question, who takes care of me or my family if I can't do it myself? In today's workshop, I'm going to explain some of the tools we use to help answer that question, although our specific focus is going to be on advanced healthcare directives. An advanced healthcare directive is one way that you can answer the question, who takes care of me if I can't take care of myself? Today, there's a very real fear that we might get sick with COVID-19 and be put on a ventilator. At present, if we're hospitalized, we can't have visitors in person. In this situation, it becomes more important than ever to have someone who can speak for us. Beyond COVID-19, there are other reasons for an advanced healthcare directive. We may have a car accident, a stroke, or be diagnosed with a form of dementia, making it impossible to speak on our own behalf. If you haven't planned in advance, the options for your care are limited, and all are underlined by a loss of personal control. What happens if you do nothing? If you do nothing and are incapacitated, then someone will have to petition the court for conservatorship. That is an expensive and sometimes time-consuming process. Plus, court actions are public records and can have burdensome oversight requirements. If you have not designated who you want to speak for you, you lose control over who that person is. In some cases, it may even be the state through the Department of Social Services. If you die without having a plan in place, the state of California has generously provided you with an estate plan. It's called intestate succession. California law provides who will inherit your assets. If you don't want your deadbeat child to inherit everything you have, you need to have a will or trust in place to assert your wishes. Another problem with intestate succession, and also a will, is that it must be administered through the probate court. Probate is a long, public, and expensive process. Probate courts are set by statute in California. They're based on the gross value of your assets. Let's look at the following scenarios. If you own a house that's worth $1.5 million, it has a mortgage of $800,000, you have $100,000 in the bank and $750,000 in a retirement account. There's a couple ways to look at these assets. First, the gross value of the estate. The gross value does not take into account any debts. So it looks like you have $2,350,000. The net value of the estate under normal accounting provisions does take into account your debts. So your net value is the gross value minus the debt, and it would be $1.5 million. The probate estate, on the other hand, does not look at either your debts or accounts such as your retirement account that has a beneficiary. Therefore, your probate estate in this example would be $1.6 million. Using the tables provided by the California Probate Code, the fees for that estate are $31,000 paid to the lawyer. And I don't know about you, but I don't want to pay a lawyer that much money. That same $31,000 is also paid to the administrator or the executive. So in total, the cost of that probate is $62,000 off the top of your estate, paid before anyone inherits anything. Another example with a more modest estate is a $450,000 house with a $200,000 mortgage, a bank account of $50,000, and $120,000 in an IRA. It's the same calculation for the gross value and the net value, but the probate fees in this case are $13,000. And again, that figure is doubled because it's paid to both the lawyer and the executor. So this would be $26,000. It really takes a chunk out of what you would leave to your family. So what are the tools that we use to prevent this? The first tool in our arsenal is an advanced healthcare directive. The advanced healthcare directive in California has 3 parts: a living will, a medical power of attorney, and a HIPAA release. We'll walk through this in much more detail in a few minutes. Next is the durable general power of attorney. This allows your designated agent to manage your financial life, including specific areas of authority: bank accounts, investments, real estate, insurance, talking with your retirement account administrators are some examples. The most versatile tool is the living trust. A trust is essentially a treasure box where you store your assets. One of the best features of a living trust is that it provides tools for both incapacity planning and planning for what happens to your assets after you die. Another one of its strengths is that the assets held in a trust do not go through probate, so the process is much faster, private, and less expensive. A trust allows you much more control and flexibility over your assets after your death. You can protect your assets from your future ex-son or daughter-in-law. You can protect your children's inheritance from their creditors and also from themselves. We'll now turn to the process of creating an advanced healthcare directive. If you download the form directive that you can find on my website, look in the comments section for a link. You'll find this directive. On the first page, you write your name. Then you designate your agent. In selecting an agent, you want to think of several characteristics. One is, who would be better than the state? The other thing you want to do is think of all the people in your life who would be able to understand what the doctor has to say, share similar values with you, and most importantly, will follow your directions rather than making their own decisions. In addition to having one agent, I always recommend having alternate agents, or to use a sports analogy, to have a deep bench. Have a second choice and a third choice. That way, if something happens to the first choice, you have a backup waiting in the wings. On the second page, there's a spot here to limit the agent's authority. You also have the opportunity to designate when the agent's authority becomes effective. If you mark this box here, the Advanced Healthcare Directive takes immediate effect. If you do not mark that box, it becomes effective only when a doctor has certified that you are incapacitated and incapable of making your own decisions for your health care. You have the opportunity to make some decisions on what happens after you die. If you would like to be cremated or buried, you can put it here. You can also include what you would like to happen with your remains. If you have made pre-need arrangements with a funeral home or cemetery, you can include that here so that your agent knows your wishes. Page 3 has the HIPAA release. The HIPAA release authorizes your doctors to talk to your agents. Without this, they could not release your medical information. On page 4 is where you have the living will. The living will is your instructions for your health care if you can't make the decisions yourself. The first choice is end-of-life decisions. At their most basic, the choice is to prolong life or not to prolong life. Prolong life means you want to be kept on life support as long as possible. The choice not to prolong life essentially means that if you have an incurable or irreversible condition and will die in a short time, you do not want doctors putting you on life support. Or if you are what they call brain dead, or finally, if the likely risks and burdens of treatment would outweigh the expected benefits. Here it's important to know that it's with reasonable medical certainty, and your agent will make this decision after talking with your doctor. Let's go back up. The last thing on this page is you can include your wishes for palliative care or relief from pain. If you want to be kept comfortable at all times, sometimes that means that you might not be fully conscious or present. You can indicate your wishes regarding that here. If you have anything else that you would like to include in your Advanced Healthcare Directive, you have space here on page 5, and you can add additional sheets and instructions if needed. Part 3 is donation of organs. There is no age limit on the ability to donate organs. So you can choose to give anything needed. You can limit, I'm okay with my heart being donated, but not my eyes. And lastly, you can limit the purposes of your donation. Some people would prefer not to be used in medical research or in education, such as cadavers. So you can cross out the things that you would not want for yourself. In part 4, you can designate a primary physician. This would be the person that your treating physician would call. If you are hospitalized away from home, your doctors could be notified if you provide this information here. And finally, you sign the document. You sign, date, and then print your name. In order to be effective, the document must either be notarized or witnessed by 2 witnesses who are not your healthcare providers, nurses, or the agents named in the document. They also have to be the witnesses have to be over 18. Sometimes I'm asked what you should do with the Advanced Healthcare Directive once it's completed. Your healthcare provider would appreciate a copy. I recommend storing the directive in a safe place. If you have a fireproof safe, that's a great place to put it. It is also a good idea to share the directive with the agents that you have named. You can scan it and send copies to them. They don't need an original. I hope you found this helpful. If you would like to schedule an appointment to discuss your estate planning needs, there's a link to schedule an appointment in the comments. And again, you can download the Advanced Healthcare Directive form for free on my website, and that link is in the comments as well. Thank you so much.